Please the court, Paul Cross from Monteagle, Tennessee, for the appellant. And I would like to reserve 5 minutes for rebuttal. I want to focus on a couple of things because it's a long case and hash out everything that's in the briefs in a short period of time. However, there are a couple of things that I think bear touching on. Maybe the biggest issue in the case, in my opinion, is the admission of the 911 calls. And it's been well briefed, I think, but I like to think I briefed it reasonably well myself, and the state's done a good job briefing it. One of the issues in this assessment is obviously whether the primary issue, whether the probative value is substantially outweighed by the prejudicial effect. One of the issues that the state has raised in its brief, and I think this was raised by the trial court as well, was that another argument that I have made elsewhere in the brief has to do with the missing shells from the pistol that shot the victim and killed her. Shot 7 times, shells couldn't be found despite perfect hunting conditions, hunting for shells conditions. The state raises the issue or the argument that the shells, no one would have had time to pick up the shells, hide the gun, whatever, hide a second gun, whatever. My argument was that, my argument was that those missing shells were picked up by someone and taken off in order to, in haste, all the shells were picked up from because there were shells from another gun in the same place. They're all picked up and they're gotten out of there to conceal the fact that there was a second gun on the premises or in the area, in the confined area. And that somehow the 911 calls, the timeline they establish, mean that could not have happened. The first 911 call lasts almost 9 minutes, 8 minutes and 46 seconds. And it is obvious that it is already the round one of the shootings when when the victim, Nicole Powell, is shot and when Mr. Hurst is shot has already taken place, and the second round, which occurs later between the defendant and Mr. Powell, starts something like 5 minutes into that. But the point is that there is at least an 8 minute, 46 second gap that anyone had, especially somebody in haste and doing a sloppy job of it, to get the shells up and get them out of there. So the probative value of the tapes, in my assessment, works against the state, not for the state.
Well, I mean, they're probative. They have probative value. They identify the location. They identify the shooter. They identify the victims. That's all extremely probative information in this case. And relevant. Do you not agree?
And other witnesses on the scene too.
Yeah.
Right.
I would agree with that, but none of those issues were even remotely controverted.
Well,
Well, they don't have to be controverted to make them relevent.
And the state still has to prove it. I mean, the state still has to prove who was injured, who did the shooting. I mean, it's relevant and it's probative, even if it's not controverted, really.
Well,
And
I do.
just a follow-up, you've indicated that there are perhaps some questions of fact, conflict in the proof, and does that not make the 911 call that was kind of a play-by-play of what was going on even more relevant?
Well, I do cite authority that if the Wooden case, it's on page 12 of my Wooden case, page 12 of my brief, if all it's doing is corroborating, in other words, piling on, that by itself is not good enough to get past 403 balancing. And I would contend that every one of the things that Your Honor mentions falls into that category, things that are totally uncontested. I want to point out another thing. I'll point this out in my big brief, but I want to point it out here as well. Mr. Steve Strain is one of the best prosecutors I've ever seen. He's very shrewd. He played this right out of the starting gate at the trial. And I know him well enough to know this was done on purpose to gather primary impact, forceful impact, to inflame the jury. And these are very, very, particularly the first one, very, very emotion-grabbing exchanges over this.
It's a pretty emotional and grabbing case, isn't it? I mean, pretty horrible facts.
Well, it's true, but I stand by the Wooten case. There comes a point at which, I think it stands for this proposition, it becomes a point at which it's just piling on. And it's piling on with something that doesn't need to be there, and it's piling on with something that's extremely emotional.
Well, Mr. Cross, let me ask this. So if you were making this argument in the trial court, you might have a receptive judge in me, maybe. I'm not sure, but you might. But we're not in the trial court.
I'm sorry?
I said, but we're not in the trial court anymore. And so we're governed by a standard of appellate review that says that this judge's decision, particularly on 403 balancing and weighing of unfair prejudice and probative value, can be overturned only if the judge abused his or her discretion. And that means that essentially that the judge is operating within a range of discretion and that no reasonable jurist could possibly have made the same decision that this judge made. That as a matter of law, almost, that call was the wrong call. That no reasonable person could make that call. And it strikes me that if we review the decision through that lens, even if I disagree with the trial judge and agree with you, that if I'm conducting my own balancing, that maybe you have the better of the argument, that on appeal we just don't get there. Because it's not so unreasonable that no reasonable person could come to that conclusion about the weight of the probative value. So, I mean, how does the standard of review work here?
Well, my response to that would be, I contend that this is unreasonable. And
As a matter of law?
Based in the trial judge raised all of the relevancy issues that are raised in the state's brief here, and they're subject to the same criticism and the same result of analysis against the Wooten case that I've cited. And from that standpoint, I suggest that it is an abuse of discretion.
Well, you noted that the 911 calls were played first, that they were the first piece of evidence. Given that, they couldn't be cumulative. They weren't cumulative of anything that was in evidence at that point. And couldn't the trial judge then have said, well, the 911 calls, they're excited utterances, and so we'll take them for their substantive value. They're relevant to identify the shooter, they're relevant to identify the victim, they're relevant to identify other witnesses, and they're relevant to identify venue. And the state has the burden on venue, of course, as it goes. At that point in the trial, couldn't the trial court have said, yeah, on balance, I think this is more probative than prejudicial?
Well, I could, the judge could have, I didn't suggest this at the trial because I didn't think it, but the judge could have delayed a ruling or made a ruling that he would make a decision on this after he saw what the rest of the proof was going to be. I submit that that would have been a reasonable way of handling this very toxic issue.
Sure. There are other reasonable ways of handling it too, right? I mean, there's not just one reasonable way of handling it. And so I wonder, I mean, are we really at the point where as a matter of law, the trial court should have excluded the evidence?
That's my argument.
Very well, okay, fair enough.
it's hard for me to see it any other way after listening to those tapes.
Okay.
But aren't they distinguishable from Wooten
I'm
as
sorry?
well? The tapes in this case, I haven't heard them, but in the Wooten case, the way it was described in that opinion is that, you know, it was like 14 minutes long. It was mostly screaming, wailing, my brother's dead. Not a lot of facts. And the way I understand the 911 call, the longer one in this case, is that it actually had facts. You know, we're here, these are the people, here's what's going on. It seems to me that the 911 call that you're objecting to in this case is distinguishable from Wooten, upon which you rely.
Well, of course, because were some facts that had to be proved by the state, and Wooten, like anything else, and the Wooten case wouldn't have gotten into the issue about whether or not corroboration is good enough had it not been an issue in the case. If I could move on, this is another issue that maybe I'm making too big of a deal out of it, I'm not sure. But there had been, in the past, apparently some mild disputes between my client and his wife, the victim. Later on, well, during the trial, the issue came up, or the testimony came up, and it had to do with a statement that Jerome Powell, the victim of a, not a fatal victim, but he got shot in this scenario, had made to a police officer. And his wife was there with him. That's Betty Powell. I refer to her as Betty. The state refers to her as Mrs. Powell because there's a whole bunch of Chris's running around, and he was also known as Chris. But anyway, or she was also known as Chris. But anyway, they're talking with this interviewer. As I say, it was his statement, but she's chirping in. And she is talking about, I do think at one point, she is talking about prior generalities. And she says, she's talking about the victim, she can hold her own, she can fight like a man, a couple other statements about like that. And then she made some reference to a gun. And Mr. Powell then kind of chirps into her chirping in and says, well, she had her gun then. The question is when then refers to.
But, well, let's be clear. Let's go through a little bit more of that. During that jury out hearing when they're discussing this, they also point out that Ms. Powell clarified that she wasn't talking about the day of this incident. She was talking about the day of the prior incidents or incident with the defendant.
Well, she first says, I can't answer that question. Then as the conversation goes on, she does.
But where I was going with this is, one, the clarification in the jury out hearing is, I'm not talking about today, so to speak, I'm talking about yesterday, right? Which would have then been her response. One would have been her response had been asked about it at trial. And then two, the bigger picture here is, in order to get that testimony out, you have to go against the motion to in limine and the motion to exclude any history of prior incidents between the two. You can't ask her that question in a vacuum and let her then try to explain it without getting to something you tried to exclude to begin with. So you can't have it both ways, is one. And then two, she explains it to at least the satisfaction of the trial court she was not talking about the day of the incident. She was talking about another day. So I'm trying to, again, we're talking about an abuse of discretion here, right? Where, based on the rationale of using those two pieces of evidence, did the trial court abuse its discretion here?
I think this should have been a jury issue. She says, for the second time, when this first comes up and she's called upon to give her opinion on this, she says, I can't answer that. Then she does come around, but then later on, she says, she says, I'm pressing her in this jury out. She says, I can tell you that she's talking about what bad a shape, that her husband had just gotten out of the hospital, he's on medication. So how is the judge supposed to read that? Other than she's, at best, does not know when this happened. The whole issue, the last thing I want to do is put this back at a prior date. And the district attorney kept trying to force it there, and that's in the state's argument here.
But that's what the trial court found, too, though. And the trial court found if you're going to let this testimony in, then we get to go back and talk about why she would feel she needed to stand there with the gun on her hip at this prior incident that they're talking about, which the trial court said you can't talk about. So, I mean, I don't see...
This can be read as a question that he's asking her, did Nicole, the victim, have a gun on her in this exchange on the day she got shot?
And so her answer there would be no. What are you going to do with that?
Well, that is the way it developed, but I think it...
But I mean, you said it should be a jury question, so I'm asking you, if the trial court had said you can ask the question you just proposed, did she have a gun on her hip that day, and the mother says no, what are you going to do with that?
Well,
you can't say anything else, because if you say anything else, I get to talk about what she really meant and these prior incidences.
Well, my point is that the jury is under no obligation to believe her. And of course, her husband says pretty much the same thing when it comes up in his testimony. But they're not, all of the taking back water and fudging that these witnesses have done, we may have hit a critical mass that the jury's not going to believe anything they say. And this issue is, if we can put a second gun on that scene, the chemistry of the case changes. It's not, Mr. Strain kept saying you're trying to get into self-defense. No, that we could get into anything from reckless homicide, intentional negligence homicide, some lower grade of homicide, or nothing at all. It's an accident.
All right, well, I don't want to eat up all your rebuttal time, so thank you. General?
I may have to pull around a little closer if I can.
That's fine. That's fine.
May it please the court, Lacey Wilbur on behalf of the state. Your honors, I will confine myself to the two issues that the defendant talked about unless you have questions on the other issues. With respect to these two issues and all his other issues, the defendant is not entitled to relief. With respect to the first issue, the trial court acted within its discretion when it allowed the state to play the two 911 calls. Your honor, as you noted, the call from Mr. Powell, the first one that was played, is a play-by-play, blow-by-blow of the actual shootings after the defendant went in the house, well, as he went in the house and got the shotgun, and then the exchange of gunfire between Mr. Powell and the defendant. That would just be like a surveillance video. We just have the audio part, but that is allowed. It's not an abuse of discretion. It's completely relevant. Its probative value is not outweighed. And with respect to Mrs. Powell's 911 call, the first one, was 7 minutes or less than 8 minutes. The second one from Mrs. Powell was 2 minutes and 36 seconds, very quick. She said, I'm at such and such address. I have 4 people on the ground in a shooting. There are children on the scene. Come here quick.
How do you respond to their argument, though, that all this proof is already in there, and all the 911 calls do are play to the prejudice and sympathies or excitement, whatever you want to say, to the jury. I mean, we got the witnesses to testify. Here's who did the shooting. Here's where it took place. Here's who got shot. Here's what guns were used. I mean, we got all that proof from witnesses, right?
Yes.
So you play these chaotic gunshots in the background, whatever, crying mothers, 911 calls. Are you not just playing to the sympathies of the jury?
No, and the mother on this call was not crying at all. She was matter of fact, short and sweet, and not crying. There's no sympathy engendered in that one. And again, Mr. Powell's call is an unfolding of the case as it happens, and that is relevant. It is not.
We have that proof.
But the state has a high burden, and is it an abuse of discretion for a trial court to allow a 911 call? This is very rarely the case. In the cases that the defendant has cited in his brief, Wooten, that was a case where a victim's sister was carjacked. She went inside her apartment, found her brother dead. The 911 call was 14 minutes long of her just crying and saying, "My brother is dead, my brother is dead." This court found that that was not relevant. It played to the jury's sympathies, but this court also found that it was harmless in light of the evidence presented at trial. And the same case with the other case that the defendant relies on, Beard, that again was a mother who came upon her dead child and prayed to God for many minutes, and that had no relevance about the issues at trial. And so again, these are relevant. They are not playing to the jury's sympathies. They are assisting the state in proving every element of its case, and it was not an abuse of discretion for the trial court to allow those two 911 calls to be played to the jury. If there are no further questions on that issue, with respect to the second issue, the trial court again did not abuse its discretion when it did not allow defense counsel to ask the Powells about what, and I think it's Mrs. Powell. It's a little confusing about who said what because we don't have that statement in the record, but I think Mrs. Powell interjected and said she had her gun then. And in a jury out hearing, she said, "No, I was referring to before she even had her toddlers, who were 2 years old at the time of the shooting." So this incident that she's talking about occurred 2 years prior to the shooting. And the trial court said, "I said at the beginning of this, prior to trial, no prior bad acts are coming in. I don't want to confuse the jury. No prior bad acts are coming in." And so the trial court did not allow that in. And we actually have at trial defense counsel again trying to make this an issue of whether Ms. Powell, the deceased victim, had a gun. She was asked directly, Mrs. Powell was asked directly, and she testified that the victim did not have her gun with her on that day. Ms. Lewis, a defense witness, testified that Ms. Powell said that the victim's gun was broken, the holster was broken, and the victim's boyfriend had it in Alabama and was repairing it. So there's no evidence. And there is a picture of the victim at that birthday party before she was shot. No holster, no gun. So there was no error. There was no abuse of discretion for the trial court saying that confusing sentence about a prior bad act could not come into evidence.
So we didn't get into this, but we're getting ready to.
Okay.
Let's talk about the sentencing in this case. Trial court gives a very long narrative when sentencing the individual. Trial court at no point in time fleshes out, even mentions Wilkerson and the Wilkerson factors.
I will just quibble with you a little at the very
Quibble
very,
all you want, because I'd like to see where it is.
Well,
I've read it, so but I mean, you can tell me where it is. I'd be more than happy to try to find it.
no, we did say that this court should do de novo review of the
Well,
Wilkerson
so,
factors.
but that's my question really to you, though, is if the trial court doesn't really address the Wilkerson factors, and in doing so, he has to make findings of fact to support those Wilkerson factors. He doesn't do that. He just kind of talks about a lot of different things. Can we really do a de novo review when there's really nothing there to even try to figure out how you would get to the Wilkerson factors, because he didn't give us a roadmap at all?
Here's my
I mean, I know we can,
Yes.
but I mean,
We argue that there is enough here because at the very beginning of the sentencing hearing, the trial court says the state is relying heavily on 4035-115 and the subsection that deals with Wilkerson. So he does mention the Wilkerson consecutive second sentencing factor. And then he gives a list of all the actions that the defendant did that day. And the trial court is saying, I'm going to consider this as two separate incidences. I'm going to consider the incident where he killed Ms. Powell and shot Mr. Hurst several times. And then I'm going to consider all the other things as a second kind of act. And he doesn't necessarily say for consecutive sentencing purposes, but that's what he's doing. And this court can infer that
No,
from
it's
there.
not necessarily. He
Yes.
does not say
He
they're
does
for
not
consecutive
say.
sentencing.
He does not say, but he said, I'm going to consider everything else he does after this, going inside the house, grabbing the shotgun, walking back out, shooting at them. And again, he's relaying all the facts that this court has read about this second part of the shooting with the shotgun. The gunshot defects on the house, the court mentions all that. And the trial court then imposes partial consecutive sentences based on he runs the first shootings concurrent with each other, and then he runs the second shootings consecutive partially to the first ones. And so I believe there is enough that this court can infer that the trial court found that he was a dangerous offender on that. And this court has enough for a de novo review. Your skeptical face says you do not believe me.
I recognize the law says that we can either do a de novo review or send it back. I'll just leave it like that.
Yes, Your Honor. Our argument is please do a de novo review. If there are no further questions, we ask that you affirm the judgment of the trial court. Thank you very much.
Your rebuttal?
Just make one brief point on the judge's comments at sentencing. I don't know really where it fits into the analysis, but he says this is an execution-style killing and that my client had his wife down on her knees. I don't think he says begging for her life, but that's kind of the picture he's painting. That's just incorrect. Betty Powell testified that she's right in the middle. It's basically, her daughter, Nicole Powell, is sandwiched between the defendant and her when really a struggle's going on, and all she hears is boom, boom, boom. She's trying to apparently get my client's
Well, at one
arm
point in
away
time,
from-
he points a gun at her, does he not? And says, stop. At one point in time, does he not point a gun at Miss Powell and tell her to stop performing CPR on her daughter?
Yes, that is.
I mean, that's one of the things the trial court
there's
relied on.
testi-
The trial court relied on that as far as enhancement, not for consecutiveness, but for enhancement.
I'm
Did he
sorry.
not?
I'm sorry. I think we're talking about two different things. I'm talking about he's talking about the shooting, the actual shooting of Nicole, not the threatening of the mother.
Okay.
But anyway, I don't think anybody actually saw the trigger being put. Nobody actually saw the shooting.
Right.
She heard. There's two people that heard it. Now, Mr. Hurst, he doesn't even put Miss Powell on the scene until later on. And Miss Powell says, as I've described it before, her daughter was basically sandwiched between Mr. Smith and her. And when the shooting happened.
Thank you.
Okay, thank you.
Thank you
Mr.
both.
Ross. Thank you.
We're going to take a quick recess.
All rise. Easier said than done. I said easier said than done.